Okay, just a few words on statutory licensing of musical works and another failed statutory attempt at licensing. Statutory licensing in general is quite complex. While the old musical works statutory license had a preset number of cents per minute in the statute, copyright owners protested this was artificially low and unresponsive to inflation. So for future statutory licenses, Congress set up provisions for rate courts. This added complexity in that the regulator has to decide how much to charge if industry players can't reach a voluntary agreement. The first negotiations about digital rates ended in disaster. The parties went to rate making by copyright royalty judges. Those judges set incredibly high rates, orders of magnitude higher than what the webcasters asked for. And webcasters went to Congress. Congress passed a law that covered through 2005. They went through the same rate making for rates retroactive through 2006. Once again, the copyright royalty panel set an incredibly high rate, $500 per channel minimum. And if you can consider what in Spotify a channel is, you will see the immediate problem. If a service provides a customized stream of music, depending on your rating of representative artists, as Pandora and Launch and many other services that existed tried to do, that seems to be one channel per user at minimum. Everyone agreed that the announced rates made webcasting economically unfeasible. Congress intervened again. The copyright royalty panel was directed to set rates that would correspond as closely as possible to what the market would have set if there had been no proceeding. Now, one might reasonably ask, what evidence could the panel possibly use to do this? But the market does finally seem to be settling down a bit and consolidating, not unrelatedly. One reason is private deals. Record labels have been cutting side deals with Spotify and similar services. They get ownership percentages in return for lower royalty payments. Note the effect on artists of this kind of voluntary agreement. If the label is taking its money as owner of the service, it doesn't have to share that money with artists, whereas if the label takes its money in performance royalties, it has to do so. So the label and the streaming services profit by recharacterizing the transaction and splitting the value that would otherwise have gone to artists. There's also significant disparity in payments. Pandora seems to be paying 12 times as much for sound recording licenses as it does for musical work licenses. Separately from the copyright royalty arbitration panels, ASCAP and BMI are also in court constantly over the antitrust rules governing their rate setting for public performance rights in musical works, which covers things like music played in gyms or restaurants that aren't protected by the 110 carve-out. One thing that we may discuss in class is the effect of the ASCAP and BMI making new rules for political rallies, withdrawing the blanket for venues. The main takeaway from ASCAP rate court litigation is this is really complicated and the parties have entrenched positions. Someone powerful will get hurt by any change. For example, Sony tried to withdraw its digital-only rights to negotiate with digital services directly. So ASCAP and BMI could not give blanket licenses for Sony works. They wanted BMI to represent it with physical businesses like gyms and restaurants. It didn't want to have to chase down every business in the country, but it thought it could get higher rates from Spotify and YouTube in particular, market leaders in concentrated markets, because the average Sony work is worth more than the average non-Sony work. The likely effects on performance rights organizations like BMI would be a death spiral. If this were allowed, they'd be left with a decreasingly valuable inventory. They could get shut out of digital rights entirely. The antitrust court overseeing ASCAP and BMI didn't allow that, but lobbying on the issue continues. So the last sort of statutory attempts to create order out of chaos I want to talk about is the Audio Home Recording Act. So we have a congressional pattern here, compromise in the face of technological innovation, here in the form of digital audio tapes, which looked like the next successful music technology. The standard pattern when Congress addresses a new technology is to expand copyright rights in response. What we got here were new restrictions on possible technologies combined with a statutory royalty paid to the labels, combined with some exceptions. If Congress is wrong about where the tech is going, it can all be wasteful and ineffective, as it was here. Notably, the required royalty for the digital audio space is on equipment and tapes. No matter what you use the recording equipment and tapes for, some money went back to the record labels. So historians who might use digital audio tape as a good medium would be subsidizing music fans. Many other countries use similar but much broader schemes, which is why iPods and hard drives can cost multiple times what they do in the US. In other countries, the royalty pools are often allocated in part to cultural preservation organizations rather than trying to compensate artists whose works are actually being copied. Also, the royalty pools are often limited to nationals from countries that grant reciprocal rights, which means that US artists are usually excluded from device royalties. Functionally, the US entertainment industry is subsidizing other nations' cultural institutions. In addition, a number of the countries with a royalty requirement, like Australia, don't have any private copying exemptions. Private copying is technically illegal, despite the existence of the royalty pool, which presumes that a substantial use for these technologies is going to be making of personal copies. One could reasonably ask, is that how we want the law to be set up? In the US, there is a non-commercial copying exemption, but only for the technology that nobody now uses. So this exemption does not apply to general purpose computers. We will talk further about the various varieties of compulsory and non-compulsory rights in class.